So, if a litigant or a petitioner before the court has a doubt in mind about the autonomy or the independence or a particular school of thought that the judge may subscribe to, if a litigant has those doubts, is it fair for the litigant to ask for a recusal? We have seen in a high-profile matter.
The test is not that a litigant has a doubt about the impartiality of the judge. The test is of a reasonable man in the particular circumstances. Can he be said to have a reasonable doubt with regard to getting fair justice at the hands of the judge or not? Now, when you talk of a reasonable man and the reasonable circumstances, the threshold is a little higher. In this case, what are the reasons which, according to me, justify a request for recusal? And mind you, request for recusal is in no manner casting any aspersion on the integrity or the capability of the judge. The only basis for a recusal is that while the judge had decided 4 bail cases in respect of accused in this very case, she had, while rejecting the bail, had said very clearly that serious charges are made out and accordingly bail should not be granted. Now, that is definitely an expression of your mind on the particular trial, and you have analyzed this very evidence, which the trial court has found to be lacking in credibility for the purpose of framing of charge. Now, if the evidence which the trial court finds to be completely insufficient for framing of charge, and you have used that very evidence to say that his framing of charge is made out and accordingly bail should be denied, then in all fairness, the judge should not hear this matter. The second ground, according to me, for recusal, I don't know whether that's a ground taken by Mr. Kejriwal or not, is that even on the first date of hearing, after a discharge has happened, the judge, without even issuing notice or ensuring the service of notice to the accused, has granted an ex parte order. Now, interestingly, in this very case, when one of the accused, Satyendra Jain, was being granted bail, or when his bail was being considered by the trial court, and the judge had posed some questions to the prosecution, which gave an impression to the prosecution that he may be inclined to grant bail to Satyendra Jain, they had immediately rushed for change of that judge, which actually happened. The change of that judge was also affirmed by the High Court, saying that a reasonable ground has been made out with regard to the impartiality of the judge or with regard to his views in the matter, which merit him to not hear this matter. So you can't have double standards in such kind of trials. And in my view, to uphold the dignity of the decision-making process and to be fair to every litigant, even in our country, even the Bombay shooting cases also, they got proper fair trial. In fact, some of the best lawyers defended them. Crores and crores was spent to keep them in safe custody till they were ultimately given the death sentence by the Supreme Court. So if people, terrorists also are entitled to a fair trial, I don't see why any other litigant in this country should not get the same from this system. So I think we are making a big issue out of this, and this should have really resulted in, because recusal is actually a decision to be taken by the judge, either himself or herself. It is not something which can be said to be, there is any straight boundaries to decide on the question of recusal. In fact, in one case, Supreme Court has, Justice A.S. Anand, if I remember correctly, had said that if there was something which the lawyer felt that the judge should know for him to recuse from the matter, it is the duty of the lawyer to inform the judge. And in fact, he castigated the lawyer for not informing him that he had actually heard this matter, although at a very preliminary stage while he was in the High Court. And he later on then recused from that matter. So these are the high standards which we, which we subscribe to. And I think it is in all fairness that to uphold the majesty and the dignity of the institution, this kind of a case, a recusal should have happened by the judge on her own, rather than delivering a very long judgment saying that why I will not recuse in this matter.